Commissioner Pillay.
Thank you, DCJ. This is just a quick follow-up. Good afternoon, Mr. Maniati.
Good afternoon.
Can I follow up on what Commissioner Nochesi has put to you? And it really is, and this is where you two seem to be speaking past each other. It's the approach that you used is an incorrect approach. If you look at paragraph 15 of your judgment, you say, in the evaluation of the facts before me, I'm of the view that the learned magistrate put much consideration to the seriousness of the offense and the interests of the society above the personal circumstances of the accused. Lastly, that the degree of severity in this matter is not that serious. You were applying the Zinn test, which is a completely different approach to sentencing. You disregarded the minimum sentencing dispensation, and that's the problem. You acted as if you've got a discretion which you exercised from scratch, and you took into account the Zinn factors. You didn't depart from the perspective that the minimum sentencing legislation is in place. That's what the legislature ordained, and your only job was to check as to whether or not there are substantial and compelling reasons to depart. That's the distinction.
As I've said, Commissioner, my approach was automatically the first thing that one has to do is to check whether there are substantial and compelling factors to deviate from the prescribed minimum sentence. What I did was to look at the factors, the facts of that particular matter, whether the sentence that has been imposed, is it disproportionate to the offense that has been committed. Now, at the same time, when I look at the fact that he was a first offender, looking to the fact that there was no violence that was used, and I've not actually planned, it was just a spur of a moment, but still the fact is that he committed this particular offense. I felt that the issue of life sentence was disproportionate to the facts at that particular time. But as I've said, if the Commission feels that that was a wrong approach, at the time, I bona fide believe that that was the approach that I wanted to do, that I was supposed to do at the time.
Thank you, DCJ.
There was a follow-up question from the virtual platform. Who was it? Have they given up? Okay.
Dodova was right after all. It's just
no, he was not right.
It
was
me, DCJ.
Yes. Who was it?
Yes, it's Clement.
Go ahead.
Good afternoon, Magistrate.
Good afternoon, Prof.
Yes. I'm also concerned with this case, in a sense that you are using the word violence. And I just want to understand in what way you are using the word violence. I cannot think of any way of thinking of violence than somebody actually violating you by putting any part of their body into your own private part. I think that is violence enough. But over and above that, I just want to understand from you, when one deals with the question of rape, are there degrees of seriousness? And what determines whether the act of rape is more serious than the other in such a way as to deviate from the minimum prescribed sentence? Thank you.
Thank you, Commissioner. As I've said, when I'm talking
DCJ,
about...
So sorry, it's the same question. I just want to add something on the same question that Prof has asked. If you allow me, can I just do it so that he package it, if it is possible? Okay. My simple question is, what is not violence in rape, especially a statutory rape? What will constitute non-violence?
Commissioner,
or put differently, DCJ. Or put differently, what is your definition of violence?
no, in this particular matter, Commissioners, I was talking about physical in the sense of assaulting or stabbing. As I've said, the fact that we take it very seriously, that any rape is serious. That's why the extended definition that if you use any part of your body, is rape. The rape is rape. But as I'm saying, you look at the facts. How is the matter being committed? How is this rape is committed? That's why I'm talking about the degrees of commission, the action itself, not the rape itself, but the manner in which the rape has been done. That's why I'm talking about that particular issue.
But DCJ,
But the rapes are all of them are serious.
DCJ. Oh. But we agree that rape is violence. Should we agree on that one? That rape on its own is violence?
Yes, Commissioner Malema, I do understand your side of the thing. That is a violation.
Side of the thing.
That is a violation of a human. And rape, as I've said, is serious. But when you look at the cases, as I've said, when I'm talking about, when I referred to the issue of violence, I was actually meaning, maybe it might have come out in totally wrong, but there was an issue where somebody has stabbed somebody or assaulted this particular woman. That's what, when I'm talking about violence in that particular sense. But I do agree that rape on its own is rape in a technical sense, is violence.
Yes, I mean, DCJ, I wonder if maybe I can help the candidate. I think the problem that you don't have to answer this because I think you've attempted to do so in response to Commissioner Pillay. I think the problem that you are being pressed on, certainly from this side of the table, is that you've distorted the test. You know, if you look at paragraph 14, in cases of this, of your judgment at page 30,
Okay, you can post it.
Do you have it?
I'll check. I'm trying to check.
no, let's just go through it together. Maybe you can concede and then we move on.
Yeah.
It's page 30, paragraph 14. It looks like you're looking at the wrong bundle.
Sorry about that.
No, I know the feeling.
Sorry about that.
Yeah, so I think the point that is being put by Commissioner Pillay is that you've distorted the law. Because the way you express the law is that in cases of this nature decided by the Supreme Court of Appeal, the message is that it's clear that life sentence is the most severe which a court can impose and must be regarded as a last option. Now that's where the distortion is. The law is that it's the first option, you know, unless substantial and compelling reasons exist. So that's where you are misunderstanding the law. That's what is being put to you. Okay. The second thing around this misunderstanding, it looks like you are not the only one, because when you turn to page 32, the judgment is concurred in by a senior judge.
Okay. I think I've got it.
Yes, but you don't have to answer because I think you've already taken enough.
Just one quick other follow-up. Mr. Manyati, you speak about the extended definition of rape. I'm not sure what you're talking about. There was a common law definition of rape, which was more narrow, which was repealed by the Sexual Offences Act in 2007. And then there's one definition of rape, which is person A who unlawfully and intentionally commits an act of sexual penetration and with a complainant B without the consent of B is guilty of the offence of rape. Full stop. That's the definition of rape. So what's the extended definition? There's compelled rape, which is not one of the factors here. That's the third person. So, I mean, even with respect, I suspect you are looking at the old common law definition of rape, which was repealed as being the correct version, and the statutory definition of rape as being the extended version. And let me assure you, it's not an extended version, it is the current definition of rape.
Yes, Commissioner, I do understand. As I've said, I think what I'm trying to say, as I've said, Commissioner, is the fact that when those issues that were indecent assault and other issues, they are now actually rape. That's what I'm talking about, because initially there's certain part of the body that was used before it can be regarded as a rape. But now the Act talks about any part of your body and any other objects. That's what I'm talking about when I'm talking about the extended definition of rape. But as I've said, if that was the wrong approach, I think it came in a wrong way, the way I put it, but that was not what I meant, and I accept what the Commission says.
Commissioner Lucas?
Thank you very much, DCJ. Good afternoon to Mr. Manyati. Is it Manyati? I was listening to the candidate, and I think I want to ask him to forget about the technical approach that he's actually bringing to this panel, and tell me whether, in the light of the high prevalence of gender-based violence in this country, someone just Monday responded to say that they realize that South Africa in some aspects can be seen as a lawless country, particularly if you look at the high prevalence of gender-based violence. Now, while he was sitting on the bench, whatever kind of judgment you give become kind of precedents. Have you taken into account how many children is being endangered by taking a decision technically that you have got, what do you call it, that you can decide discretion, that you have discretion whether you want to impose a minimum or a maximum or a minimum sentence. Have you taken into account how many of us, or do you expect us as women here to agree with you and say that you are fit and proper for us to recommend that you should be appointed? Because we are very disappointed, and I don't become appalled anymore. What is happening is that it is very, very painful to hear someone speak and making something that is so painful a technical issue. DCJ, if you allow me, I want to tell you, I was in the United States of America earlier in last month. And you know, because of the time difference, we are reading South African news all the time. For the 4-5 days that I was in America, every day, 2 women at least was killed and raped. And that is why we don't know how someone can be technical about the issue of rape.
Thank you, Commissioner.
Thank you.
As I've said, Commissioners, I take rape very seriously. Maybe the manner in which I've put it is the weights in that particular judgment sends maybe a wrong message. In my instinct, as a judge in this province, I've actually done more than, I think, 5 cases that has to do with rape, where the accused has been sentenced to life imprisonment. Last month, I think in January this year, in Captain Park, I sentenced the accused who was sleeping with his own daughters, that are 3 of them, that were underage. I gave him 3 life sentences plus 30 years on top of that. What I'm trying to say is, I'm very much sensitive to the gender-based violence. I think some of the cases that I've gave to you, that shows that I'm very much sensitive to those particular issues where gender-based violence are involved. You can see also in one of the cases that I've quoted, the one of Palisa Modiba, a UJ student. I'm very much serious about those particular issues. But as I'm saying, that I might have use a language that is actually not correct in this particular matter, but that on its own, as I've said, I think I will have to look at that at the next time as to how do I put that in a proper perspective. But I take gender violence very, very much seriously.
I think the difficulty, Mr. Manyati, is that you strenuously defended this obviously flawed judgment of yours. And it's not just the reasoning. Well, you are backtracking on your reasoning now. But the sentence you imposed there shows exactly what, how you understand the notion of rape. You imposed a mere 12-year sentence, which backs your flawed reasoning. How do you account for that? And then you come here today and you continue to defend this judgment when so many people are trying to show you where you went wrong. I've not heard you concede to this point that you were wrong in that judgment.
Thank you, Commissioner. As I've said, that I thought that the way I put it and the manner in which I've done, I was of the view that I'm in a right track. But as the commissions are pointing out, I cannot dispute what their views is. But at that particular stage, that means that next time I have to be very much careful about that particular issue. I do agree and accept what are they saying.
Commissioner Balwe?
Thank you, DCJ. Good afternoon, Mr. Manyati.
Good afternoon.
DCJ, my question, in fact, becomes a follow-up on what you're saying. Mr. Manyati, the courts speak to the public and to the parties that appear before them through their judgments. And it is therefore important that the orders that you get to are reasoned. When you read the body of the judgment, as a party that before you, when you read the judgment, you want to see an explanation of why an order was given. You reduce the sentence to 12 years. There's no reasoning why 12 years. Why not 5 years? Why not 20 years, right? So this child of 13 who has been subjected to violence, because it is violence, has been subjected to violence, has no idea why you have reduced the sentence to 12, why in fact it is 12 years. And all you tell us is you've taken into account the personal circumstances. And the only personal circumstances in this judgment is the accused is 39, he's got a son of 17, he's an IT specialist who earns so much. Those are the only personal circumstances that are in here. And we have to have, you want the public to have faith in the decisions of the courts and how they come to the decisions of the court. But it will not happen if we don't explain ourselves. And I make the point because whether you get appointed or you continue to act, you are going to continue writing judgments, even if you're acting. You have to understand and appreciate that you owe it to the public to explain your orders. You have failed dismally to do this. In fact, as a result, the impression is, well, you take rape lightly, this kind of rape lightly, hence the 12 years.
Thank you, Commissioner.
Thank you, DCJ.
As I've said, I do accept, as the Commission is of the view that that is the issue, I do accept that maybe I've made a mistake. I do understand in respect of the approach. But at the same time, as I've said, I promise that I also take that serious, any rape matters, as well as any gender-based violence offenses, I take them into seriously. But I do understand what the Commission's concern is. But as I've said, I will try to next time to sort out the way that I've done it, the approach that I have.
Mr. Manyati, you've come 7 years after you've done this judgment. You've heard all of us say you can't justify your sentence and your reasoning And yet you continue to say, I hear what you say, which means your view hasn't changed and we haven't helped. So what do we do? Which appears that you've written the judgment today, the way you're defending this. You come here for an interview. We're telling you about the difficulties. We're telling you that there was maybe an error at best for you, and you don't admit that. You justify the unjustifiable, and you continue to do so today. And I have great difficulty with that. That causes me serious concern.
Yes.
Because I see this judgment as if it's written today. And by the way, it's not a 12-year judgment, it's a 10-year judgment, because you antedated this judgment.
Yes, Commissioner, I do understand. Maybe I don't put it, I do accept that the commissioner's view, I do accept that maybe the approach was wrong. I do that I was wrong, and I've said it's one of those regrettable errors, and next time I'll try to be able to do that. I do agree and accept the commissioner's view in this particular matter.
Yes, Commissioner Malema.
No, just a very brief follow-up. Apart from the law that the other side has shown and everybody else has spoken, in particular Commissioner Lucas, and how this has become a huge problem. Now a cardinal mistake has been pointed out to you that child will never recover from. That the admission you are making here now confirms that she has never received justice, she will never receive justice. In the spirit of Ubuntu and Africanism, having accepted all of this wisdom that was shared with you, Judge, collectively, don't you see that you should take this opportunity to really, sincerely apologize? Because it will go a long way to heal some of the wounded women of our country who have fallen victim of this. And there is a general acceptance that they are not. Is there a problem, Commissioner Nonjes? No, but I see you two citing the DCJ with a hand sign. You want to stop me?
Commissioner Malema, time is against us. Eh?
So I thought the acceptance will not just be an acceptance, will be accompanied by something beyond that, because we're now going beyond the law and all of that. Seated here, we can't correct that ourselves. We don't have that power. But seated here, we can reach out in the spirit of Ubuntu and say, this wisdom has opened my eyes. I'm really sorry. And in future, I'll correct it. A lot of people will find a lot of sympathy out of that. Not that we're trying to find any legal correctness or anything of that sort. It has been pointed out. The victims are watching. Commissioner Lucas made a very clear plea of what our women have been subjected to. And when they rush to justice, they don't get justice in the manner it has been presented to now. Will it cause any harm to just say, I accept I was wrong and I sincerely apologize?
Thank you, Commissioner Malema. I think I was trying to say that my approach at the time, I thought it bona fide, believed that it was the right approach. I realized, as the Commission is saying, that it was not the right approach, and I apologize for that, as I've said. Going to make sure that this particular mistake does not happen again, and I assured you that even if after this, there are my cases that has to do with this type of crime, the appropriate sentence was imposed. So I'm sorry about the approach that I've used, and I'm wrong.
On that note, we have reached the end of your interview, Mr. Manyati.
Thank you. Thank you very much, Commissioner.
You're excused.
Thanks.